Hello, everyone. Good morning, and thank you for joining us today. We're extremely excited to explore the variety of ways that compliance and enforcement programs can produce more equitable environmental outcomes. Today's first webinar on environmental justice and compliance and enforcement will examine how justice concerns are arising and being addressed in several different regions. It will include a brief overview of the problem of ensuring equitable enforcement of environmental laws, and then include a series of questions designed to help understand how environmental justice issues are being addressed in different regions around the globe. Our program today will be moderated by Mark Ungar, a professor of political science and criminal justice at the Graduate Center of the City University of New York. His publications include 5 books and about 40 articles on police reform and environmental crime. His most recent book is titled The 21st Century Fight for the Amazon. He is an advisor with the United Nations, the Inter-American Development Bank, and the U.S. Department of Defense, and is currently directing an initiative at USAID on organized crime in Central America. At INEAS, the International Network for Environmental Compliance and Enforcement, he is the co-chair of the academic committee, which brings together environmental faculty from around the world. Mark, do you want to take it away?
Thank you, Ceylon, and thank you everyone for joining. Good morning, good afternoon, good evening to everybody. We are privileged to have such a strong set of specialist policymakers with us today to discuss this important issue. And I want to just start by introducing each of them so we have a sense of their incredible background and experience. Our first speaker, or the speakers that will go in turn, is Anne Brosnan. She is the president of the European Network of Prosecutors for the Environment, the deputy director and chief prosecutor for legal services with the United Kingdom Environmental Agency, and a board member of Interpol's Pollution Crime Working Group. She was critical to the introduction of the English environmental civil sanction regime in 2010 and has extensive experience in implementing effective and equitable environmental governance. Our second speaker is Deb Hollingsworth. She was the principal solicitor of regulatory standards and enforcement and the environmental justice advisor at the Environmental Protection Authority in Victoria, Australia. She recently explored the application of environmental justice into environmental regulatory practice in the UK and Norway, and also led her authority's Aboriginal Inclusion Action Plan. Her primary areas of focus include Aboriginal self-determination and public interest legal practice. Our third speaker is Loan Yuen. She is a senior attorney with the US Environmental Protection Agency. She has extensive experience in civil enforcement of environmental statutes and in the analysis and development of legislation and policy affecting environmental enforcement. In 2008, she was counsel for the EPA's Office of Environmental Justice, and since then has advanced environmental justice through enforcement policy and legislation. Our next speaker is Cristobal de la Maza. He is Chile's Superintendent of the Environment and has notable experience in engineering, public policy, machine learning and statistics, environmental and energy economies, and risk perception and communication, among other fields. Between 2011 and 2014, he led the Environmental Enforcement Information and Economy Division in the Ministry of the Environment, heading the design and implementation of the National Green Growth Strategy of Chile and the National System of Environmental Information. He's also director of the Latin American Network for Environmental Enforcement and Compliance, Red La FICA. Cynthia Barzana Gutierrez, our next speaker, is the Vice Minister of Water and Seas for Costa Rica's Ministry of Environment and Energy. She specializes in environmental and urban law and was previously the General Director of the National Environmental Technical Secretariat. She also helped construct regulations governing environmental impact assessment procedures and served as an external consultant for the International Union for Conservation of Nature in the drafting of the Central American Code of Ethics in Environmental Matters. Kira Eli, Ariel King, our next speaker, is the Environmental Justice Staff Attorney of the Environmental Law Institute. She has a strong background in environmental racism analysis, political ecology, critical race theory, sustainability, civil rights law, and the integration of equity and environmental justice considerations into climate action plans. She is passionate about making environmental education inclusive and accessible for all. I will pass it on to Ariel, who will introduce the agenda for today. Thank you.
Good afternoon or morning or evening, depending on where you're joining us from. My name is Ariel King, and I have the honor of working as the Environmental Justice Staff Attorney here at the Environmental Law Institute. And first, I want to respectfully acknowledge that I am currently in Washington, D.C., the traditional land of the Nacotchtank or Anacostan people, and pay my respect to elders both past and present. We are building a robust and practical environmental justice program here at ELI, in addition to working to ensure effective reflection of EJ principles and considerations across our research, publications, and educational activities. We have two areas of programmatic focus at this point. First, the EJ Lawyering Program trains environmental legal professionals on civil rights lawyering techniques, civil rights lawyers on the inverse, and provides opportunities for all attorneys to hone their skills in community lawyering in preparation for pro bono work. One component of this work is ELI's new pro bono clearinghouse that will be launching soon. Another big focus of this program, is the Environmental Justice Corporate Policies Program, where we are focused on partnering with corporations, communities, and policymakers to work forward environmental justice goals and identify best practices for community engagement. And as we see solutions through these programs, I look forward to working with many of you viewing this program today. In its nascent stages, this program is primarily focused on providing tools and solutions to achieve environmental justice here in the United States, though we have a goal of expanding programming internationally, since environmental justice is a global goal and the impacts of environmental governance decisions do not remain solely within our geographical borders. While the term environmental justice was coined in the United States and the movement stems from the movement for civil rights in the 20th century, as low-income people and people of color bore the negative impacts of unequal enforcement of environmental laws and regulations, unequal access to clean water and clean air, and receive a higher amount of environmental burdens with fewer benefits than their more affluent counterparts, we recognize that these themes of power, privilege, and income status have historically overlaid environmental governance and regulation globally as well. Climate change is fundamentally an issue of human rights and environmental justice that connects the local and the global. And studies have shown that climate change will cause human migration and displacement more severe than any war globally. As a changing climate continues to threaten the stability and preservation of our planet, now more than ever, we must prioritize those who have been overlooked in environmental law and policy making and ensure that their needs are centered in decision making and planning going forward in order for climate solutions to be just, equitable, and not exacerbate the harm already experienced by frontline communities globally. With rising temperatures, human lives, particularly in people of color, low income, and indigenous communities, are affected by compromised health, financial burdens, and social and cultural disruptions. And those who are most affected and have the fewest resources to adapt to climate change are also the least responsible for the greenhouse gas emissions, both globally and within the United States. And for these reasons, I look forward to today's discussion on environmental justice and compliance and enforcement. And I thank you for the opportunity to share these brief remarks. Thank you so much.
Thank you so much, Ariel. And thank you for laying out such important foundations and issues that we all will discuss today. We're going to turn in a minute to the presentations of each of our speakers. But before then, I want to just briefly have an opportunity to give a bit of a context for policy frameworks to understand some of the challenges that we'll be discussing. Because we're so happy to have you today to have this opportunity to discuss all of the collective challenges and possibilities that we face in developing effective responses to the greatly disproportionate damage of pollution, environmental degradation, and climate change on low-income communities, communities of color, and indigenous communities around the world, as Ariel had mentioned. Among the challenges that we're facing are the range of specific and urgent needs of each community, a very broad range of demands and interests that they each have. And also the fact that many of these communities, most vulnerable to pollution and environmental degradation, often have little power to change national policy and discriminatory actions by the state. To help the panelists' discussion of these issues and to link some of their points, I wanted to propose three overall frameworks that may help tailor environmental justice policy to both specific locations as well as the larger context of national policy and politics. One of them is understanding community-level networks of power. in each community, it's important, I think, to understand the exercise of power, who has actual power in each area, such as organized crime, the police, agricultural interests, and how the collective and individual use of that power damages the environment and damages the communities. So, for example, I work in the northwest region of Honduras, where the coasts have been completely polluted from pollution, hospital waste, on top of flooding from climate change, sea level rise, and back-to-back hurricanes last year. The communities there have lost all their means of survival, which are fishing and farming, but when they tried to relocate to higher land, they were expelled violently by the police, in part because local officials were allied with the palm oil plantations dominating the area. In each area that we all work in, we see these networks of abusive power destroying communities around the world. A second area I think that we should look at is the chain of enforcement, understanding all the stages in how environmental regulations are actually enforced, from monitoring regulations in vulnerable communities at the start to evaluating the impact of sanctions at the end, to pinpoint weaknesses at each stage. So, for example, geographic isolation, lack of access to economic opportunity, lack of water testing or chemical labs, and political interference in communities that are vulnerable. At the beginning of this chain, for example, is the lack of information from the community. With distrust, corruption, and violence, means that little information from the community actually gets incorporated into policy. When information is provided, there's a question of whether there's actual follow-up. Up until the quarantine, I was working in the Amazon regions of Colombia, where there's been much better monitoring of deforestation. But the alerts of deforestation don't always lead to actual investigation and prosecution of loggers. So understanding the weak links at each stage, I think, is important, and one thing that we'll discuss a bit more today. The third context, of course, is the state of democracy around the world and the systemic weakening of judicial mechanisms, the strengthening of physical repression, and this, of course, most directly affects communities that are suffering most from pollution and environmental degradation. So environmental justice measures should try to highlight and incorporate as much as possible larger struggle for citizen and human security reform, such as more police accountability and more judicial independence. So, for example, in many of the illegal gold mining areas around the world, more help for young women who are trafficked and subject to slave labor, assessing how military operations affect indigenous communities, giving judges the ability to process cases amid budget limits and political interference. So I hope that these three contexts will help provide some connections among the speakers as they discuss these issues in their areas of the world. I will focus on the presentations are focusing on a specific question that we have sent to the panelists. And that question is, describe it how your enforcement agency takes into account environmental justice when planning and carrying out its compliance and enforcement activities. That will be the focus that connects many of the speakers. We're asking each speaker to speak from 7 to 10 minutes. As a time check, I will hold up a sign, if you can see this, at 6 and then at 9 minutes. So you know when your time is close to ending. So we will begin with Anne, who will be speaking first. Thank you.
Well, good morning, dear colleagues who are delegates attending the conference this morning. I'm going through, I can see Victoria's presentation at the moment from Deb Hollingworth, so I'm hoping we'll get to my slides in a minute. I have got 7 to 10 minutes, so I'm just going to try and be as brief as I possibly can in terms of identifying the major pieces of work and pieces of action that are ongoing in both the UK and in Europe in relation to environmental justice. So thank you very much, Mark, for the introduction. Thank you, Ariel, for explaining the background and context of environmental justice to us. I speak for prosecutors, both in England, in the UK, and for the European Network of Prosecutors for the Environment. So because I'm talking about England and Europe, it's going to be fairly brief, but there's a lot of signposting and flagging of other materials that you might wish to go to and have a look after I have spoken. So can I just say in relation to NP, the European Network of Prosecutors for the Environment, that we are an association of state actors, of prosecuting authorities And accordingly, we have a narrow interpretation of environmental justice. And the interpretation for prosecutors is really applying relevant legislation and government policy to protect the environment in a manner which is transparent, fair, consistent and proportionate to all sections of society, to be accountable in relation to the enforcement decisions and actions of our respective governments, to ensure an equitable and sustainable approach to securing environmental compliance. So can I have the next slide, please? What that means in Europe, which I hope we're coming to in just a second, is there a number of, there's an enormous amount of legislation in Europe, regulations and directives, which will be coming shortly. And against the background of all of this legislation, various action needs to be taken as regards enforcement and compliance. Can we move on to the next slide, please, Sila?
Yes, I'm trying to press it now. Chandler,
Okay.
for some reason this slide isn't moving. If anyone else is able to, oh, there we go. Thank you.
There we go. Thank you. Thank you very much. The biggest piece of legislation really relevant to environmental justice is the Environmental Crime Directive, which you'll see is a piece of 2008 legislation. And that sets the background and the requirement on member states to allow for, to provide for the criminalisation of environmental offences. And so that provides, Mark referred to the chain of regulation, that provides the facility for prosecutors to take action and bring environmental offences before the courts. Now, the interests of those affected by environmental offending is secured through very many pieces of legislation. One of them that you should be aware of is the Victims Directive, which requires member states to provide a victim's right to review. And there are other actions across the EU which are designed to ensure environmental justice and fairness for all sectors of society. One of the principal pieces of work that's been going on for some time is DG Environment's Environmental Compliance Assurance Initiative, which was a multi-stranded piece of work which was designed to ensure that environmental legislation translated into action on the ground, and that was launched in 2018 and continues. Another piece of really important legislation is the Aarhus Declaration, to which the EU is a signatory, but also it is pan-European. It has a number of member states and countries which are signed up to it. This, I think, is absolutely fundamental in Europe, the Aarhus Declaration, with its 3 pillars: access to information, the right of public participation, and access to justice in environmental matters. I looked at the Aarhus website and it describes this declaration as the only legally binding global instrument in environmental democracy. So please consider that, and there may be others wishing to challenge that. But for us in Europe, Aarhus is fundamental. And I just wanted to mention before I finish here that the European Green Deal is a new initiative. It is an initiative of the EU, and it's a major piece of socio-political work. It's an EU policy which protects the environment and seeks to minimise risks to climate, human health and biodiversity. The policy aims to make Europe the world's first climate neutral continent, in part by developing cleaner sources of energy and green technologies. So let's move on quickly, if we can, from Europe to England, which is where I work within the Environment Agency. I'm an embedded prosecutor. I have a team of prosecutors who deal only with environmental pollution offences. But my organisation's principal aim is achieving sustainable development. So what we see is that the action we take is part of the overall approach to securing sustainable development and environmental justice in England, in the UK. A couple of really important documents by which that is achieved. The first that I wanted to mention is the Code for Crown Prosecutors. And when we commence legal proceedings, we are obliged to follow this code. And there are 2 relevant, really, there are only very few factors that we are asked to specifically address our minds to. And one of those in the Code for Crown Prosecutors has 2 relevant themes. One is what are the circumstances of and harm caused to the victim. So we must have specific consideration to interests of victims. And what is the impact on the community? So we must look at the specific community and the impact of environmental offending, with some guidance which says the greater the impact of the offending on the community, the more likely it is that a prosecution is required. The prevalence of an offence in a community may cause particular harm to that community, increasing the seriousness of the offending. And the community is not restricted to communities defined by location and may relate to a group of people who share certain characteristics, experiences or backgrounds, including an occupational group. So that is all within our consideration when we decide what enforcement action to take and what prosecution activity is appropriate. Both EU legislation and UK legislation provide for a victim's right to review, to challenge us if we decide that action is not appropriate. And that's a very strong, a very powerful right in the hands of victims. I couldn't move on from what we do within the UK, within England, and we mustn't just look at the UK as England only. There are prosecuting bodies in Wales, Scotland and Northern Ireland who have a similar approach to ourselves. But there are also NGOs, non-governmental organisations and others who work in environmental justice and challenge us and hold both government and those arm's length bodies of government that are the delivery bodies to account. And I mention here the Environmental Law Foundation, Client Earth and the Environmental Justice Foundation. If I can go on to my last slide, Sila, I'll just say a little bit more about those to conclude. So the environmental justice movement in the UK focuses on issues of poverty and the environment, but also tackles issues of health inequality and social exclusion. And it's really any civilized country is likely to have a social deprivation index whereby you can look at the most affected communities and those who are most deprived and disadvantaged. We look in environmental justice terms to secure justice for all without fear and favour, but we are subject also to the likelihood or the possibility of review challenge by organisations such as the Environmental Law Foundation, which I simply mention because it is very legally based, a national UK charity founded in 1992 that helps people use the law to protect and improve their local environment and quality of life. You may have heard about Client Earth taking the UK government to task in terms of air quality legislation. And these NGOs that I've referred to have a valuable role to play as environmental defenders, and our HOOS brings into play a mechanism for protecting environmental defenders and those who are seeking to challenge government and who might be subject to harassment or harm as a result thereof. So I think, Mark, that I'm within my time. I do have the opportunity to come back on any of this later if there are questions, but I'm going to finish there and say thank you very much to ELI for the invitation and pass back to you, Mark. Thank you.
Thank you very much. We will have time for questions at the end, incorporating your questions as well as questions by the other panelists. We'll now move on to Deb Hollingsworth, and special thanks for joining us at this late hour.
Well, good morning, everybody, and thank you very much for the opportunity to participate. I would like to commence by acknowledging the Bunurong and the Wurundjeri, the traditional owners of the land on which I'm presenting to you from. They are members of the Kulin Nation here in Melbourne, Victoria. And I'd like to pay my respect to their elders, past, present, to their laws, to their cultural values that the Environment Protection Authority seeks to reflect within its work that it does to protect the environment. This morning, I wanted to, in approaching the question, to speak with you about the new Environment Protection Act that has been just come into force in Victoria. And perhaps just for context, I'm sure people possibly know this, will know that Victoria is a state in Australia. Australia, like the US and many countries around the world, is a federation. made up of states and territories, and each of our jurisdictions have different environmental laws. We don't have a national environmental framework that is shared, which is problematic. So I'm speaking about the laws of Victoria. Perhaps if we can press the next slide, thanks. Okay, so Victoria, down the bottom, right down under. My topic is a new paradigm in environmental protection, which also brings with it new opportunities to take environmental justice into consideration as part of our compliance and enforcement, but actually as really a part of a whole new regulatory way of protecting the environment. If I can have the next slide, please. So what's new about the new laws in Victoria? When we get to this slide, here we go. Victoria, like many other jurisdictions, has had pollution-based offences. And it still has those, but in a very different way. The new model and design of the Environment Protection Act in Victoria is modelled on the Occupational Health and Safety Framework. It is designed around the notion of prevention, the prevention of harm to human health and the environment. It achieves that by introducing a general environmental duty. That's the centrepiece of the whole legislative framework. That general environmental duty is criminally and civilly enforced. It's an obligation that is on all Victorians. Any activity that they pose that presents a risk of harm to human health and the environment from pollution and waste needs to be identified. There's an obligation to eliminate, and if elimination is not possible, to take the reasonably practicable measures to minimise the risk of harm. And the offence and the newness in the application of this in environment protection is that the offence, the contravention occurs when the steps are not taken to minimise. So that's the prevention framework. Can I have the next slide, please? And I think, as you can see, very new for us and has required the development of a whole new organisational operating model, systems, policies, procedures. So actually, you know, the question about how we take environmental justice into consideration, I think remains to be seen actually in this new legislative framework, because we're new with pretty much everything actually. But I did want to say that this legislative framework really has an environmental justice context. It comes on the back of, and people will be familiar with this right around the globe, of high profile environmental pollution cases impacting more than anybody vulnerable communities and of people in low socioeconomic circumstances, often living precariously close to industry. The catalyst, the Morwell Hazelwood mine fire, an open cut coal mine, you know, at its closest point, 50 metres from the township of Morwell in Victoria's Latrobe Valley, burnt for 45 days, blanketing the residents in the area in dangerous air pollution. That was the trigger for an inquiry into our environmental laws and the way in which the Environment Protection Authority needed to be equipped to operate rather than chasing pollution events to prevent them. The next slide, please. So what have we ended, what have we now? Listening to Anne reminding me of Aarhus Declaration. Our laws are very much modelled around those three pillars, thank you, of access to information, citizen participation, and with it much stronger protection laws, very much supporting that general environmental duty. Next slide. So that's the framework by which the prevention is to be achieved. Might have skipped a slide there, I think. But we know that prevention isn't always achieved. The new legislative framework includes opportunities for environmental justice outcomes, particularly through restorative justice. Actually, no, let's press on. That was the next. Sorry, Sela. If we can. One of the things that the EPA has been working on, partnering with the Australian National University, is a joint project on looking at environmental restorative justice. Apologies for this slide. The quote there is from Professor John Braithwaite, the Doyen of responsive regulation, many of you will know. And he says, because environmental crime hurts, justice should heal. I think my slides might be slightly misordered, and we'll get to the next one, but the provisions of the new Act include restorative justice provisions, thank you, that allow for citizen participation through the sanction enforcement process, allowing opportunities for citizens, those directly and indirectly impacted, to present to the court the impacts of the environmental justice issues for the adjournment of proceedings to achieve restorative justice processes. And something that we have in the 1970 Act and has continued on is the opportunity for courts on hearing the impacts of offences on the communities of people that have been, not just the environment, but also the communities, for the court to order a restorative project that benefits the community and the environment. The new provisions in the Act seek to achieve a balance of punitive, deterrent, and also restorative outcomes. I may be running out of time. I've got 2 minutes left. If we can go back to that slide that we've been over, and I will just finish on that one. I did just want to explain, so that's going backwards, apologies. Thank you. The Restorative Justice Project has looked at a number of ways in which environmental prosecutions and enforcement action can benefit communities and also traditional owners through the mechanism of restorative restorative project orders, enabling outcomes to not only impose penalties on those that have committed the offences, but also to achieve multiple outcomes for those that are impacted. One case in particular is the awarding of $100,000 to traditional owners in the Bendigo area, the Dja Dja Wurrung, enabling a traditional waterway assessment, which allowed the identification of cultural values of the waterway that was impacted by the Water Corporation pollution. That's an example of one of the outcomes that we would hope to be seeing more of, not only just prevention, but also to achieve better environmental restorative justice outcomes. I could go on, but I think my time is up. So thank you very much. And thanks again, everybody, for the opportunity to participate.
Thank you so much, and I'm sorry we have such limited time for each person with the wealth of experience and information you're providing, but hopefully we'll get back to this in the question time. Our next speaker from the U.S. Environmental Protection Agency is Loan Yuen, who will be speaking next.
Good morning, everyone. So at the U.S. Environmental Protection Agency, we do understand that one of the ways compliance and enforcement programs can produce more equitable environmental outcomes is by first and foremost making enforcement a top priority in your region. And then on top of that, strengthening enforcement in areas disproportionately impacted by environmental pollution. And in the current administration here in the US, enforcement is a top priority at EPA. This administration recognizes that EJ issues are complex and rooted in generations of inequities and injustices. Through recent executive orders, they've mandated a whole of government approach to advancing equity and justice and have squarely placed the White House at the lead for the government's work. Federal agencies like the EPA, the Department of Energy, the Department of Transportation, Department of Justice, Department of the Interior will play a critical role in supporting this whole of government approach. EPA will certainly support this approach by sharing the benefit of our years of experience in advancing environmental justice through our environmental protection activities. Indeed, EPA's journey began 50 years ago when citizens demanded a clean environment and basic public health protections. Our administrator, Michael Regan, is committed to delivering on our agency's promise to protect human health and the environment made to all people in our country over 50 years ago, putting environmental justice at the forefront of our work today, including enforcement of environmental violations with disproportionate impact on overburdened communities. For the past 25 years, the Office of Enforcement and Compliance Assurance at EPA, my office, in partnership with our regional enforcement programs, has built environmental justice principles into our enforcement program. As a matter of fact, until 2019, our office coordinated environmental justice work for EPA when the agency's Office of Environmental Justice was part of OECA. We helped lead an agency-wide effort to develop both Plan EJ 2014 and the EJ 2020 Action Agenda, and spearheaded early efforts to develop EJ Screen, the agency's widely recognized and award-winning environmental justice screening tool. So our office, the Office of Enforcement and Compliance Assurance, is well positioned to continue advancing environmental justice in communities with energy and ideas. Our acting assistant administrator has communicated clearly to staff in the program the importance of environmental justice and issued new policies and directives to enhance our work in overburdened communities across all enforcement and compliance assistance programs. The new policies instruct enforcement and compliance assistance staff to, one, increase the number of civil enforcement inspections, enhance civil enforcement case remedies, and increase community engagement in our civil enforcement work. He also instructed that we improve our criminal case remedies and assistance to crime victims. Another policy directed us to facilitate faster Superfund and hazardous waste cleanups, increase cleanup oversight, and provide more cleanup information to communities. And fourth, another memo encouraged the use of the full array of policy and legal tools to ensure benefits to affected individuals and communities, including advanced monitoring, audits, electronic reporting, and the posting of compliance data. Our program has stood up an EJ steering committee made up of headquarters and regional enforcement program managers to oversee the implementation of these policy directives. The steering committee has convened several cross-OECA and regional work groups, including more than 160 staff that are building out activities to implement the policy directives in those memos. With input from management and staff in all 10 of our regions, as well as each OECA office, the steering committee is developing an EJ action plan. We will work with our partner offices within the agency and as much as possible community stakeholders to solicit input on the plan prior to finalizing it. We're improving on early and more frequent engagement with tribes and pollution-burdened communities affected by enforcement decisions. Some examples: we're providing more civil enforcement information to communities about facilities, pollution and enforcement activities through press releases, desk statements, public meetings, and websites focused on very specific communities. We're developing transparency tools to provide the public with enforcement and compliance information about their community. Several enhancements to our enforcement and compliance history online website, or ECHO, will be available in the next few months and include ECHO Notify, which is a listserv service that will notify individuals about enforcement activities specific to facilities in their area. Our criminal investigation division is utilizing the Nextdoor app and has sent out the first Nextdoor messages to residents in Jefferson and Galveston counties in Texas. EPA is the first federal agency to use this platform to conduct outreach to local communities. We're increasing opportunities for community engagement in the development of cleanup and reuse agreements to ensure community concerns are addressed in a meaningful manner through revised model documents that include new provisions regarding community involvement. For example, requiring potentially responsible parties to provide information to the public in the dominant languages of community members with limited English proficiency. And we're promoting environmental justice with other federal agencies, such as leading a series of meetings about EJ best practices with the Department of Energy regarding Oak Ridge Reservation to improve community engagement. We're collaborating with the Department of Defense to protect military families from lead paint-based exposures, conducting EJ screen training for other federal agencies such as NASA, and we've launched a comprehensive EJ webpage on federalcenter.gov, which is the compliance assistance website for federal agencies. I could speak much more to the things we're doing, but I'll yield my time and return to some of this information in the question and answer period. Thank you.
Thank you very much. Yeah, and there's so many questions that we'll be able to discuss in the question and answer period. Our next two speakers are Cristóbal de la Maza and Cynthia Barzuna Gutierrez from Latin America. Thank you. I think you're on mute.
Should Cynthia start first?
Apologies, greetings to everyone from Costa Rica. I thought Cristóbal was first, but I would just go ahead and talk about today the Regional Agreement on Access to Information, Public Participation, and Justice in Environmental Matters in Latin America and the Caribbean. Thank you. So through the approval of 2030 Agenda for Sustainable Development, the member states of the United Nations established a path towards greater dignity, prosperity, and sustainability for the people of the planet. It is the only legally binding agreement originated from the United Nations Conference on Sustainable Development, Rio +20, the first treaty on environmental issues in the region and the first in the world to include provisions on human rights for defenders in environmental issues. The Regional Agreement on Access, known as the Escazú Agreement, was adopted in Escazú, Costa Rica on March 4, 2018. It confirms the value of the regional dimension of the multilateralism for sustainable development. It aims to fight inequality and discrimination and guarantee the rights of people to healthy environment and sustainable development, paying special attention to vulnerable communities and placing equality at the center of sustainable development. The Escazú Agreement is an international treaty signed by 24 Latin American and Caribbean nations concerning the rights of access to information, public participation, environmental justice, and healthy and sustainable environment for current and future generations. 11 ratifications were required for the agreement to enter into force, which was achieved on January 22nd, 2021, with the incorporation of Mexico and Argentina. The agreement entered into force on April 22, 2021. The key elements of this agreement are that it strengthens the links between human rights and environmental protection by imposing requirements upon member states concerning the rights of environmental defenders. It aims to provide full public access to environmental information, environmental decision-making, and legal protection and recourse concerning environmental matters. It also recognizes the right of current and future generations to a healthy environment and sustainable development. The agreement at a glance right now, 24 signatures and 12 ratifications. We still have to get more ratifications, of course. And just as a general fact, 23 countries have enacted Freedom of Information Act. 76% of these countries included provisions to promote public participation in general environmental laws. 20 countries allow any person or group to bring actions in defense of the environment, and only 6 countries include something that has to do with protecting the defenders. So what's next? Countries must ratify the treaty internally in order to gain the full beneficial aspects of the agreement. Once ratified, countries must create the right platform in their governmental branch to enforce the agreement. And this could be finally a model agreement for other regions suffering from human rights issues regarding environmental justice. So that's my part, and I leave the rest for Cristobal. And by the way, Chile and Costa Rica were the nations in charge of this agreement.
Thank you, Cynthia. That was a great presentation. This is a very important agreement for the region. So now I would like to focus on what we'll be doing on the ground. Like I direct SMA, the Superintendents for the Environment of Chile, which is the independent lead agency in charge of enforcement and compliance for the environment. And I agree with Loan, it's hard to talk about environmental justice if you run an environmental agency, because all what we do is leads and is focused to promote environmental justice overall. The next slide, please. And this story, as Cynthia mentioned, started 10 years ago in Rio+20, when with my colleague Constance Nalegat, we were dreaming about expanding Principle 10 of Rio 92. And that actually happened and fostered a lot of energy on how to promote and deepen environmental democracy in Latin America and the Caribbean. And the main focus is to strengthen human rights, right? The access to participation, environmental information, and access to the judiciary system, right? And an enforcement and compliance agency has a lot to say about these goals. The next slide, please. So in a concrete example of environmental justice, we focus as SMA prioritizing efforts in territorial and intergenerational justice. So of course we are intensifying our actions in overburdened communities by pollution, but also we're focusing our efforts to protect environmental heritage for future generations. Next slide, please. So how we do this? We aim to cover 100% of relevant facilities in these territories. Here we have an example of the Bay of Quintero, which has been exposed to pollution by 50 years, mainly power plants and refineries of all kinds. And we defined 20 of these facilities, and so far in this region, we cover 100% of those, and we initiate prosecution actions for half of these facilities, which will lead to corrective actions at the end. Next slide, please. We selected 28 territories in the whole country, and we plan to expand to 60 more territories with these characteristics next year through a participatory process. Next slide, please. This is an overarching initiative, so we are taking an integral approach, not only focusing on enforcement and compliance, but also in strengthening monitoring systems, information, public participation, and giving priority to complaints. Next slide, please. Next slide, please. So we are now monitoring our efforts in these territories. Here we have the screen for one of those. Tierra Amarilla is a mining region where we also have we advance with corrective actions for those in non-compliance. Next slide, please. But this is not only about enforcement and compliance, we also strengthen public participation in this process. By law, we are obliged to consider as a formal part of any process to those that present complaints. And we expanded this process by allowing this to take place electronically. That tripled our complaints this year compared to last year. And also we are signing agreements with municipalities to have physical offices throughout the whole country, giving more access to the judicial system at the end. Next slide, please. And with information, we just launched our environmental intelligence strategy that mixes and strengthens artificial intelligence. So we are not only making available information for the public and encouraging more informed decisions, also making information available for machine, make it findable, accessible, interoperable, and reusable by algorithms. Finally, I will like to, the next slide, please, highlight that a good example of intergenerational justice includes ensuring the integrity of greenhouse gas mitigation regulations. So we launched a series of regulations demanding continuous and real-time monitoring of those affected by this type of legislation. Thank you very much.
Thank you very much. As our final speaker, we're very fortunate to be joined by Benson Ochieng. He is the Executive Director of the Institute for Law and Environmental Governance based in Kenya. He's also a lawyer and professor specializing in sustainable development law and teaching environmental governance at the University of Nairobi's Center for Advanced Studies in Environmental Law and Policy. In addition, he has advised governments on negotiations of multilateral environmental agreements and the development of climate change responses and strategies, as well as action plans. Thank you and welcome.
Thank you very much, Prof, for that generous introduction. It's my pleasure to be here. Good afternoon, good evening, good morning. It is afternoon where I am. I'm happy to join you. First and foremost, let me clarify that I don't work with an environmental protection agency or a government agency. I am an independent, let me say, expert on these matters. Maybe that gives me greater flexibility to explore the issue at hand. May I start my presentation giving some perspectives on environmental justice and how it plays out in environmental enforcement and compliance. I know probably the expectation is that I would cover the region, East Africa, but let us clarify a few things. First, when discussing environmental justice in the context of East Africa, we have to deal with some three important issues from the outset. Let me just name them problems. The first is the issue of identity. And I say this because I've seen in describing or trying to unpackage the idea of environmental justice, certain terms like indigenous or color have been used. As good as they are important in defining environmental justice or conceptualizing it in certain contexts, there could be political sensitivities around that, because like in the region where I am, the question of who is indigenous and who is not is a hotly contested political issue. Governments prefer to use other terms, or rather everyone considers themselves indigenous. So when we approach this agenda in the regional context of East Africa and generally Africa, we do well to be sensitive to those terms. So a more general term of vulnerable groups or marginalized group is more acceptable, but again, with different nuances in different places. So you can see the issue of complexity starts to come in. Two is the issue of sovereignty. In as much as we normally want to identify ourselves as kind of homogeneous or brotherly or fraternized in a certain context, it is normally a different ballgame when you start to define legislation and enforcement in a regional context, particularly in East Africa. We have been working on a regional bloc with a certain degree of nostalgia, because in the late 60s, I think members of the European Union came to learn about regional integration and regional economic blocs from the East African community. But it has never gelled as it has happened in Europe, to the extent they can develop national legislation from EU directives and develop common instruments of the like of Aarhus, which set certain standards and practices across the board. So the issue of sovereignty is important. And lastly, there is the issue of regime inflation. Let me call it so for lack of a better word. But over the years from independence, legislation on environment have been formulated piecemeal, building upon each other, many times without proper consideration on what has been done in the past and trying to align that to the times of the day and to the issues of the day. So you have a broad, multiple regime of institutions, regulations, and legislation. Sometimes they are duplicitous and sometimes they are in outright conflict with each other. So all those influence the context in which we pursue this matter of environmental justice. Having said that, let me underscore certain important things. One, the region is very ripe for this agenda of environmental justice. Those of us who have been following the global political economy issues will realize that the region has recently experienced a lot of discoveries of oil and gas, particularly in Uganda, Tanzania, and Kenya. And these have attracted a lot of interest in development and investment. And so that poses great challenge for environmental management institutions or environmental enforcement, and particularly for governments, because on the one hand, you are talking environmental justice and seeking to protect the rights of vulnerable groups or marginalized groups. But on the other hand, you want to uplift their economic status and so that you lift them out of that situation. So there is a paradox and a kind of contradiction, a problem with the two sides that you really have to put in perspective. The second is that the regions have just opened up for economic investment, and we're seeing a lot of new infrastructure developments. Part of it would definitely help to lift people out of poverty. But then therein lies the problem of environmental justice, because you are going to be undertaking certain actions. They don't necessarily have to be mutually exclusive, but what I'm underscoring is that it presents a very difficult challenge for the environmental management or enforcement institutions. The third is climate change. It is an interesting dynamic that it pervades and affects virtually every community with various degrees, and particularly the vulnerable and marginalized groups. And finally, there is a great drive for industrialization. Every government is having in its economic blueprint the issue of we need to industrialize by a certain date. Third, let me just now deal with the issue of the policy terrain and just highlight some of the areas. Yes, I see you. Thank you, moderator. The policy landscape is very interesting. What has happened is that we are seeing considerable constitutionalization of principles of sustainable development and the idea of environmental justice, basically also codifying some of those principles, procedural rights and substantive justice issues around environmental issues. And that is very important. It is happening across the board in all the countries. We have also seen considerable development in environmental framework laws, which are elevated to the level essentially of being mother laws on environmental issues, so that other sectoral laws are required to align with those. And this is very important because it gives a degree of prominence to environmental issues and to environmental institutions. There is also considerable development in sectoral laws, and again, these a lot of times are codifying these modern or emerging principles of environmental law: sustainable development, precautionary principle, polluter pays principle. These are helping a lot environmental activists, human rights activists, and lawyers like us to combat this issue of environmental justice. And of course, arming the environmental enforcement institution with the instruments and force to back up themselves when they want to pursue environmental justice. Fourth, we've seen a lot of growth of specialized institutions and environmental enforcement institutions, including specialized courts. Like in Kenya, 2010 Constitution and establishes a land and environment court, which is also a superior court of record. And the idea is to elevate issues of environment and land, and particularly develop jurisprudence around those issues. I'll just take 3 more minutes here and finalize. So apart from that, we have seen a lot of innovation in the instruments that are coming into place. Some remedies specifically tailor-made to address issues of environmental justice, like environmental restoration orders. And of course, in Uganda, they have recently passed a law which innovatively has got this principle of extended producer liability, where, for example, those who package using plastics have responsibility to ensure that they are collected or repatriated back to the factory at a certain time. And these are very important in helping to further this agenda of environmental justice. So we are also seeing a lot of development of appropriate instruments, particularly environmental impact assessments. And these are becoming more and more innovative. They are moving away from the traditional EIA into more sophisticated issues like, yes, Chair, integrated environmental impact assessment and strategic environmental impact assessments. And these are providing very good room, because in those processes or procedures require filling in forms that specifically demonstrate you took account of issues of vulnerable groups and ensure public participation, and you conduct monitoring and continuous environmental audits. So let me leave it at that. I believe during the discussion we will have time to talk about challenges, but just enumerating, there are persistent challenges of resource constraints, inadequate jurisprudence, because this is just an evolving concept in some cases. There is inadequate consciousness among communities on what is really the scope of environmental rights. There is the issue of regime inflation. And finally, there is inadequate political will. I told you governments are weighing between whether to pursue economic development outright or to pursue environmental justice. And where there is not enough sufficient political will, economic side is always carrying the day. Thank you very much, Chair.
Thank you very much. We appreciate your important talk. And we're now going to open it up to questions and answers. There's a box in the chat where you can pose your questions either to the entire panel or to specific panelists. And I apologize ahead of time if we don't select your specific question, but we'll try to select those that represent the larger categories of questions being posed. I will begin with a question that was sent to the entire panel. And I would also ask in your answers, if possible, to address 3 additional issues. 1, how do you identify communities that you should prioritize for environmental justice action? Do you have sufficient funding to do so? And what is the role of community-based monitoring in these projects? So the first question we've gotten from participants to everyone on the panel is, how do laws and policies in your countries or your state define terms such as overburden, disproportionate, or vulnerable to identify so-called acceptable levels of risk from pollution versus injustice and acceptable risk or harm? Whoever would like to go first to answer that question.
Can I pick it?
Yes, please go ahead.
Yeah, I identify this as a challenge from the outset. In our case, laws have failed to define the scope or clearly what these terms mean. And despite the misgivings of many governments to accept certain terms like indigenous or identities on the basis of color, let alone the fact that there are certain nuances or hesitation with some global trends like identities on the basis of sexual identity, which in some cases is a cultural issue, and people are very reserved about discussions of that kind or venturing into that kind of dialogue. And so I would say that unfortunately the laws have not given much guidance in terms of defining or disaggregating these terminologies, and it doesn't help in the understanding of environmental justice and how to frame it.
Anyone else would like to go? Go ahead. Anyone who would like to speak? Oh, Anne?
Oh, just very briefly, just identifying communities. I thought that was a really interesting point. I was very interested to hear from Benson about the way of describing complicated groups and mixes of people as vulnerable or marginalized groups. And I thought that was a much healthier approach to this than trying to push people into compartments and compartmentalize their needs or their difficulties. We would have a look at social deprivation index. We'd also look at the geography of disadvantaged areas. We have in Europe the Eurostat, which picks up statistics about communities, and the European Regional Development Fund, which can identify areas across the EU which are designated as low income, deprived or disadvantaged. So those sorts of labels can be quite useful for communities seeking a higher level of protection. Thank you.
Cynthia?
Thank you. In Costa Rica, we have a mandatory law that that makes it mandatory consultation for the indigenous communities. We do have to consult before conducting any kind of project in their lands. So this is one example in Costa Rica, and we have tried something as well called COBIRENA, which is a commission, a group of people in various communities that they do this without any compensation at all. It's kind of a citizen science kind of movement, but a bit different because they don't have the science, they only have the knowledge that they want to participate and help the communities. So they have been key to let them know what rules and regulations we have and apply. And as they have conducted this participation process where and also we have 4-digit line, free line for complaints. So they have been very useful in letting everyone know that they can call, they it could be anonymous and they can make this anonymous complaint. And the government is, it has to conduct an investigation with regards to the issue that's being put up on top of the table, that it's the complaint that we received. So that being anonymous has helped a lot, and we have used this commission Covidena, which it works everywhere in the country. They know their community well, they know their neighbors, so they have spread the word, and that has helped a lot. Thank you.
Thank you. Cristóbal?
Yeah, just to add, at least in Chile, we don't have a formal definition of overburden, but in our legislation, cumulative impacts are covered. So it is a fact that has to be considered through an environmental assessment process. Also, when you discuss a legislation, you're forced to analyze distributional impacts of that policy on how impacts affect disproportionately, for example, the poor or the native population. But at the end, a quality standard is a social agreement. So we have a formal process on how to establish quality standards, air, water, soil, but we have advanced more with air quality than other environmental components. So that is leading to sites, to territories that are affected in multiple dimensions, and that are lacking a formal definition of how to tackle those problems.
Thank you. Anyone else would like to address this question? Odette?
Just to follow on from that, Victoria also has resisted, I think, a formalised definition of environmental justice or an overburdened community. But that's not to say that there isn't, you know, an understanding across our jurisdiction of what is variously described as our hotspot areas, and it has coincided with you know, initiatives to increase the amount of air quality monitoring, compliance and enforcement activity. And those particular districts are very much informed by you know, socioeconomic data of you know, where there is social disadvantage indicators. But one of the things that we did try and do is to introduce something a little bit like the EJ screen and you know, a similar you know, program in California, and it really became quite a hot potato. There was it became very difficult to, you know, press ahead, because there is this reluctance, I think, to, you know, perhaps box and define. So I, you know, perhaps that's shared around a number of jurisdictions. But something that's new in the new legislation that will be very interesting to see how it plays out is the focus on human health as well as environment. And there's a definition in the new legislation that recognises cumulative impacts. Now, that hasn't been defined, but I think that there is the opportunity to apply, you know, the understanding of where there are overburdens to then perhaps then consider that, because we actually have this definition of unacceptable risk of harm, that we may see license proposals being refused because there is an unacceptable risk of harm, because there is, the social indicators that indicate that there are communities that are overburdened. That's really going to be very much up to the EPA to invest in those kinds of initiatives. But I think that really the foundations, the provisions are sitting in the legislation.
Thank you. Would anyone else like to address the question? If not, we'll move on to questions that were specified for specific panelists. Our first question is for Anne Brosnan, and the question is, how can you make states like Serbia comply with various European directives and conventions, particularly the Aarhus Convention, which is not respected by those governments? Anne?
Well, that's a big question. We can only encourage states into the fold as regards Aarhus and compliance with Aarhus. We try and secure environmental justice by taking action within the EU in relation to failures and pollution incidents within member states. I don't believe that Serbia currently qualifies there, so its involvement, its signatory to the Aarhus Convention is a matter between itself and the committee. But really, as a starting point, the government has to be signed up really to make a meaningful commitment to the pillars of Aarhus, rather than being obliged by other member states or by the EU itself. So sometimes these things take time and encouragement.
Thank you. Our next question is for Deb, and the question is, in Victoria, when the courts have heard the impacts on communities, what examples of restorative justice outcomes have you seen? What has happened that wouldn't have happened otherwise without hearing from those communities? Deb?
Okay, thank you. Look, I'd like to perhaps say that one of the things about the new legislation is the opportunity to hear more directly from communities. What has happened with the provisions in the 1970 Act is that it's the EPA, as in the course of its prosecutions, has exercised the opportunity of a provision in the 1970 Act to seek from the court a restorative community-based project and to bring the community in that way. And we've certainly seen outcomes that have been restorative to communities. I think, one of the emerging initiatives that we can see is for traditional owners, First Nations peoples, as they seek recognition and nation building that and healing of country, that we can take a bigger perspective on what an environmental crime means and recognise that there is pollution and waste and there are communities, but actually there are traditional owners who are seeking to restore and heal country and have cultural values recognised. So I think, we've really started on that journey. We've sort of just recently, a number of orders as part of our prosecutions. But going forward with the new legislation, their opportunity for impact statements, restorative outcomes is much more prominent. So I would like to think that we will, in the future, there'll be a different answer to that question.
Thank you very much. Thank you. Our next question is for Lauren, and the question is, what training or background is required of EPA staff on the Environmental Justice Steering Committee? How do you ensure that the actions or directions that come from the committee accomplish environmental justice? What?
Yeah, so I will speak to, so the Environmental Justice Steering Committee that I spoke about is comprised of managers from the Enforcement Compliance Program. I can speak to their training and their experience. So the managers on there are longtime practitioners in enforcement and compliance, and our program having the benefit of years of sharing the space and the responsibility for environmental justice at the agency with the Office of Environmental Justice, our colleagues for years. We, in that partnership, we've sort of led the way, led by example, in terms of training our staff and managers on environmental justice and what it means in the context of enforcement, what it means to not only look at enforcement and build in considerations of environmental justice into, and you spoke about the chain of enforcement, right? From the beginning, when we're looking at we're looking at compliance and we're monitoring for compliance, and we're looking at considering communities that are located around facilities that may not be in compliance, and looking at factoring in considerations of potential impacts to that community, right, over the years. And then if we decide to take further and take enforcement action to continue to consider the community and the impacts and their location here, and within our authorities, consider information that they've brought forth, or consider information that are in the region, which is they're located closer to the communities, have from the community about the impacts from those facilities, and then carrying that information as much as possible into our resolution of the enforcement action in our negotiations with the defendants and our settlement discussion. So we've, like I said, over the years in our role in leading environmental justice at the agencies, we like to term it as we baked it into our process and our policies, and revised our policies over the years to recognize the impacts and the changing conditions out there.
Thank you very much. We have just a couple of minutes before we turn to the wrap up, focusing on future conversations. And this is a question for anyone on the panel who would like to respond, which is what training, capacity building, or information might be most helpful for your organization in building environmental justice considerations into your compliance programs? It's a broad question, if anyone would like to respond to it. If not, we'll come back to our final section on, Benson, go ahead.
Yeah, let me handle that. Though, as I said, I don't work for an agency, but I've seen some very positive developments that have happened, particularly with cooperative or joint approaches to training, particularly for the judiciary. As I indicated, we've seen considerable evolution or establishment of specialized agencies, specialized courts, specialized institutions for prosecuting environmental offenses. What is lacking is that these institutions have no precedents or sufficient jurisprudence to rely upon whenever they are dealing with this kind of issue. And more so in the context of the various nuances that I did indicate in terms of conceptualizing the whole idea of environmental justice, the social and political undertones surrounding this matter are sometimes so sensitive that you need to approach these institutions very deliberately with the right information and the right training. So in the East African region, I've seen civil society organizations partnering with UNEP and academic institutions like the center where I teach to develop curriculum on environmental law. And you can tailor-make that to specific issues, for example, environmental justice and how it builds upon and helps to develop a framework for realizing certain fundamental rights and freedoms, which are also new entrants into the constitutions of these countries. In Kenya's 2010 constitution has a Bill of Rights that is very elaborate on environmental rights and duties, but its whole scope and how it should be interpreted in the context of addressing or linking livelihoods with governance and the issue of environmental justice has not been explored enough. So where we have done training for these new institutions, the prosecutors who are dealing with wildlife crimes and offenses and trying to understand how these underpin overall development is very important. But not just these specific institutions, even making the executives and the policymakers to understand the real import or implications of the decisions around environment and how they contribute in the wider context of national development is very important, because as I did indicate, oftentimes when they are faced with making an environmental justice decision and an economic decision, they err on the side of environmental, on the side of economic development, as it were. So those could be some of the examples or essential issues to consider in training to support efforts for environmental justice.
Thank you so much. Really important and fundamental points. To finalize our webinar, we'll return to ELLI to discuss future conversations that we'll be having. Thank you.
Thank you all so much.
Yeah, I'm going to speak briefly on behalf of INEAS and ELI. So this is Lee Paddock. I'm the managing director for INEAS. First of all, I want to thank all of the panelists for wonderful presentations today. I think this gives us almost an unprecedented view of how environmental justice is being taken into account in compliance and enforcement around the world. And we want to continue that conversation. So we welcome ideas about whether it's information exchange, capacity building, training programs, sharing literature that we can facilitate through the INEAS Secretariat at ELI to help advance the implementation of environmental justice in the compliance and enforcement context. I want to particularly thank Deb for being with us at something like 2 or 3 a.m. in Australia time. An amazing contribution. Thank you so much. And thanks to Mark and all of the panelists for their contributions today. You can correspond with INEAS through Selah Bell or through by contacting me, and we welcome your ideas and your thoughts, and we look forward to future programming on this important issue of environmental justice. Thank you all, and I believe we have come to the end of our time.
Thank you.
Thank you.
Thank you so much, everybody.
Thanks, everyone. Hope to see you soon.
Thank you so much, everybody. It was great to share the floor.
Work out how to leave. Crumbs.